When are student sit-ins protected by the First Amendment? What do we do when a coach's actions cross the line from maintaining team cohesion and discipline to becoming draconian? If absolute power corrupts absolutely, what does school spirit do?
Another athletics case here. Cheer squad again.
Yeah, our second cheer squad case.
All right. Well, today we're going to be stepping onto the cheerleading mats to explore these questions and discuss the 2019 case of Gonzales versus Burley High School. This one is pretty crazy, folks. In part, it has to do with students being punished for protesting, which is something that, as we know, has been in the news quite a bit recently. Now, while this is a K-12 case and not higher ed, and while the circumstances here are really different, it just got us thinking about student protests. And hey, I know a guy who wrote a book about student protests.
Yeah, who?
Chris Thomas, you know him?
Passingly.
You might have met him once or twice. Huh? Yeah, check out Chris's book. What's the title, Chris?
Reclaiming Democratic Education, Student and Teacher Activism, and the Future of Education Policy.
Yeah, go check it out. It's on, where is it, Amazon?
You can find it on Amazon. It was published by Teachers College Press.
Excellent. Okay. So, student protests, folks. This case has so much, so buckle up. It's got favoritism. It's got retribution. It's got grudges. It's got a coach's rulebook that reads more like a dictator's manifesto than a cheerleading guidebook. It's got a laundry list of discipline.
Are we pivoting into reality TV now?
Yes, we are.
Let's do it.
It's true crime for teachers, right?
Pretty much.
But it's also got a little youth resilience in the face of injustice.
Mm-hmm.
So grab your pompoms, people. This case has a lot of S.P.I.R.I.T. Oh, boy.
Oh, yeah! So the kids are all right. So the kids are all right. So the kids are all right. So the kids are right.
Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our school.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Talking Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are all right. So the kids are all right. So the kids are all right.
All right, Chris, what's our bell ringer today?
So we've got an update on a case that we covered in episode 12. So this is Mahmoud versus McKnight, which, Jamie, do you want to remind us all what that case involved?
Yeah, so Mahmoud versus McKnight. Feel free to jump in if I miss anything here because it's been a little while. That was episode 12. That was the case that dealt with the Montgomery County Board of Education's decision to add some children's books that included LGBTQ representation to their approved reading list.
Mm-hmm.
And if I remember correctly, the big issue was the board's decision to include the books, and more importantly, to remove parents' ability to opt out of the curriculum when those books were being used.
Yeah.
Right?
And remember, that was the 24-hour flip-flop. Do you remember that?
Oh, yeah. Right. Yeah, the board said, yeah, you can opt out. And then 24 hours later, they were like, no, you can't opt out.
Mm-hmm. Right, exactly.
Yeah, so they had no opt-out option here, and the religious families wanted to be able to opt their kids out because they believed exposing their kids to those books violated their religious beliefs and values.
Yeah, that's exactly it. So do you remember how the trial court ruled?
I do. They ruled for the school, right?
Yep.
So they upheld that no opt-out policy.
Yeah, gold star for Jamie.
Okay, so So what happened, Chris?
Yeah. So the
Why is this a bell ringer now?
because the Fourth Circuit issued a decision affirming the trial court's decision. So we've got a decision from the appellate court. This was issued May 15th of 2024. It was a 2-1 decision, so not unanimous. There was a dissent. But the appellate court affirmed the denial of the parents' preliminary injunction.
Oh, so that just basically means that the school can maintain their no opt-out policy.
Yes, the school can maintain their no opt-out policy while this case keeps moving forward.
Okay.
Yeah, so the appellate court here had very similar logic to what we discussed in our previous episode. They pretty much approached it the exact same way as the trial court, where they said that exposing students to these ideas about LGBTQ individuals didn't necessarily require them to believe anything or to change their practice or to act differently. So in that sense, it didn't really burden their religious expression. And without that burden, you can't make this free exercise claim. So there's no reason to have a preliminary injunction. So the trial court and the appellate court are pretty much talking from the same playbook here.
What happened is the preliminary injunction was denied, so the school can maintain this no opt-out policy, which basically means that these parents and any others who object to those books can't opt their kids out.
Correct.
At this point.
Right.
So the two paths that could potentially be explored from this point is either the parents can appeal that decision to the Supreme Court.
Correct.
Or that could actually go back down to the trial court level, right? And actually play out at the trial court level.
Right. Yeah, those are the two paths. So if the Supreme Court, well, one, they would have to appeal it to the Supreme Court, the parents would. And if the Supreme Court takes it up, then we'd get a Supreme Court decision on the preliminary injunction issue. Otherwise, if they don't appeal it, which chances are they're going to, it's whether the Supreme Court decides to take it up or not.
Right.
Regardless, I think we'll probably see an opinion from Justice Alito.
We often see opinions from Justice Alito.
Especially when it has to do with religious freedoms, right?
Yeah, again, so like what would happen here is appealing to the Supreme Court isn't necessarily going to be, they're appealing the ruling about the preliminary injunction. They are not appealing any sort of ruling on whether or not the inclusion of those books was appropriate, or the opt-out policy was violated constitutional rights. Like that would have to go back down to the trial court. They would have to wrestle with that piece, right?
Which is going to happen no matter
somewhere,
what,
right?
Unless the parties settle it. And that's kind of a big piece of the kind of preliminary injunction calculus is if you win or lose the injunction, then that kind of tells you how the courts are thinking about the merits of your claim. So it incentivizes.
Yeah. How strong they are too. Like, yeah.
Exactly. Yeah. Yep.
Okay.
So we'll keep an eye out to see what happens, but
totally
nice to know that we don't have to re-record episode 12 now.
Yeah, exactly. All right. Well, let's move on to the case. Today, we're going to be talking about Gonzales versus Burley High School. So in this case, students accused the school of violating their First Amendment free speech rights when they objected to how their cheer coach was treating them. Both the school and the students filed motions for summary judgment here, which means what, Chris?
Motions for summary judgment essentially mean that they went through some discovery. So they took depositions, interviews of witnesses, that sort of thing, document production. And now both of them think that they are entitled to judgment as a matter of law because there are no questions of material fact. So basically, it's a decision without a trial.
Okay. So in other words, both sides are saying we're not really disputing the facts here. Okay. So we're trying to get this thing dismissed because it's obvious that no law was broken or violated or whatever. The school was within its rights to discipline. And the students were basically saying, it's so incredibly obvious that you've violated our rights.
Yeah, there's no disagreement about what happened, or if there is disagreement, it's not important to decide the issue.
Exactly.
And so they both think they win on the record.
Right. And so, I think that's important to kind of emphasize here, because what we're about to do is go through and tell you what the court documents indicated happened in this situation. And so a lot of times, depending on, how far they get in the process, you could be hearing one side of the story more than the other, right? And it's important just to acknowledge that at the outset. And in this particular case, at least we've got a situation where, because they were both filing motions for summary judgment, we can at least assume that both sides had the ability to sort of give their side of the story.
Yeah, to put forward evidence.
Okay, so here we go. This story takes place at Burley High School. It's in Idaho. It's like the southeast direction of from Boise, less than 10 years ago. So this was, around the 2016, 2017-ish school year. The Burley High School cheer squad found itself riding pretty high under Coach Heidi Smith and a couple of years of state championships in the 15-16 school year and the 16-17 school year.
Hey,
yeah,
there you go.
They were doing
back to
very
back.
well. Back-to-back state championships under Coach Heidi Smith. In the spring of 2017, so at the end of the 16-17 school year, probably somewhere around the time that they won that second championship, Lane Mansfield was hired as the new coach. And apparently that marked a significant turning point for the team. And as you can probably imagine, not a great turning point.
Yeah, if we're talking about it, chances are that, let's call that the inciting incident.
Yes, exactly. So almost immediately, concerns about Mansfield's temperament and lack of fairness were circulating in the cheer community. So during tryouts for the 17-18 school year, one of the cheerleaders, Victoria Aragon, I hope I'm pronouncing that, could be Aragon, but
could be Aragorn, right? Lord of the Rings?
I don't think they're the same
No, there's
family.
not another R.
No, maybe not relatives.
No.
So Victoria was a rising senior who had been on the championship team for the past couple of years. Now, she did not make the cut under this new coach.
Wow.
Yeah. Okay.
So on varsity for 2 years, won 2 championships, doesn't make the team.
Didn't make the cut. Okay.
With the new coach.
Right?
Uh-huh.
Okay. Stuff happens. I get it.
Sure.
It's hard to know why she might have been cut. All that we know is that she was on the team for a couple of years. This new coach comes in and she's cut. Okay. Now, according to the court report here, it was due to a personal beef that Mansfield had with Aragon. Okay.
Oh, no.
So, yeah, I guess there was some sort of personality disagreement or something between the two of them. And that was sort of the reason for her being cut.
Okay.
Now, here's where things start to get pretty funky. So the court report states that Mansfield prohibited the other cheerleaders from communicating with, associating with, or otherwise talking about Victoria while at cheerleading practice or in the presence of Mansfield. I mean,
wow.
What's going on here? So
the cheer coach is telling the cheerleaders who they can be friends with?
I guess that, it sounds like the coach didn't like the kid. So she prevented everybody from even mentioning her name at cheerleading practice.
Okay.
Like, seriously?
Yeah.
Okay.
That seems, that's one of those moments where it's like, I don't know if that's necessarily within your authority.
Right.
But maybe from the coach, like there's a team cohesion issue where like, but we don't know anything about.
Yeah. It's hard to get into these people's heads. Look, for all we know, maybe Victoria did something, pretty egregious and really offended the coach.
Could have been harmful for team morale.
I mean, who
team
knows?
Cohesion, whatever it might be.
There's nothing in there that indicates.
Still, the idea though of telling students who to be friends with as a coach, like now.
Yeah. No, that
by itself without more information seems to be crossing a line.
Exactly. Okay. So it says that Mansfield verbally reprimanded the cheerleaders if she observed them communicating or associating with Victoria.
Including outside of cheer practice?
That was a little harder to discern.
Okay.
Whether this was like, listen, if it was in cheer practice and Victoria shouldn't have been there in the first place because she was cut from the team, maybe that's a different situation. But it was hard to tell whether or not they were referencing these communications or associations happening during cheer practice or, in that sort of context, or, Was Mansfield walking down the hall in between second and third period and saw her cheerleaders,
Right.
Communicating with Victoria and then reprimanded them for that? I don't know.
Right. Because that's some Mean Girls stuff, if that's what was going on.
I know.
And this is a coach, not another student.
Yeah. But wait, Chris, there's more.
Of course there is.
Yeah, so apparently Mansfield favored the younger players. Okay. She was an assistant coach on the junior high team. So
Before getting that.
Yeah. Before getting this gig.
Okay.
And so she knew a lot of the folks. She knew a lot of the players who were with her on the junior high team who had just sort of come into the high school.
Mm-hmm.
And interestingly, one of those players, one of those cheerleaders on the younger side was her daughter.
Oh.
Yeah.
That changes everything.
Yeah, that's helpful, right?
That's some good context here.
Yeah.
And so that's just a really complicated dynamic by itself where like if you're trying to coach your daughter, like there's that huge issue about like fairness and impartiality, right? And like even if you get up to that line where like there's an appearance of impartiality, like I can see why that would probably ruffle some feathers.
Right.
If there's these allegations that she's favoring the younger players.
Right. I'll give you an example of where this sort of perception of favoritism came from. It looks like Mansfield had a mandatory attendance policy for practices and events for I guess it's the varsity team for those older cheerleaders. There was a mandatory attendance policy for practices and events and didn't allow for exceptions for conflicting school-related activities, for family functions, or for any other non-emergencies. So it was like...
Yeah, that already sounds draconian, right?
Yeah, like you've got to be here for practices and events. I don't care if you've got a family function. I don't care if it's a school-related activity. As long as it's not an emergency, you have to be here. And if you aren't here, you're going to be excluded from pretty much everything during that particular week. If you missed practice on a Monday, you're done for the week. Okay.
And that was applied consistently to all of the cheer members.
Well,
right.
It sounds like it was not. So one example was one of those cheerleaders missed a practice because she was attending a previously scheduled school yearbook camp. And on top of that, it sounds like Mansfield allowed her to attend that event. Mansfield had given her permission months before to miss that practice. Okay. But she was then excluded from the cheer parade that week, the week that she missed that practice due to going to the...
That was excused?
That was excused.
Oh, no.
Okay. So that's the kicker, right?
Yeah.
She excused her for this event and then turned around and excluded her from the events that week. And then, interestingly, there's a kicker to the kicker. Was that Mansfield would reschedule the entire junior team's practice when her daughter or other members of that team had a conflict.
Oh, so there's the favoritism issue. Yeah.
Okay.
Yeah. Like you've got to be really careful about these dynamics. And it doesn't sound like this coach may have been being as careful as probably she should have been.
I think that's a fair statement at this point.
A fair understatement?
Yeah, exactly. So you might think at this point, it's pretty clear that we've got some problematic actions or behaviors or whatever coming from this coach. But we're not done yet. There's more. It looks like Mansfield also bullied cheerleaders by degrading their skills and looks.
In for a penny, in for a pound, right? Like
I guess go big or go home, right?
If we're already claiming favoritism.
Listen, and we've talked about sort of bullying students before on this podcast.
Right. I think that was our second episode,
I think it might have been, yeah. So Mansfield apparently told cheerleaders that they, quote, sucked and that she had no idea how they ever won a state title, unquote.
Some good motivational talk.
Yeah, exactly.
Right.
She claimed they looked trashy and gross, or they looked really dumb, ugly, or sloppy.
Less motivational.
And talked negatively about individuals to other team members, including describing one cheerleader as, quote, the most loud, obnoxious person she'd ever met, and complaining how lazy another cheerleader was.
And this is all to other cheerleaders?
Yeah.
Like, oh my gosh. So I made the Mean Girls joke, right? Like, but it sounds like the coach here is the one in high school.
That's what it sounds like.
So like, I know we have no context for how old she is, but if she has a daughter on the team, she's got to be old enough to know better, right?
Well, you would think so. I mean, listen, you would hope a 22-year-old coach in, in a position like that would know better. But regardless, here we are.
With coaches that age, though, like there's that issue where like you just kind of fall back into old habits where like you don't have necessarily enough separation between you and the kids you're coaching. But like here, there's a significant age gap that would seem to indicate to me that like you don't have that same concern of falling back into old patterns where you just become another member of the team.
Right. So if you're not already convinced that this is problematic, but wait, there's more.
I was worried that wasn't going to be enough.
So there were some safety concerns as well. So in cheerleading, there's something called a flyer, right? And these are the people that, they get tossed up in the air and they flip around and they get caught.
Okay.
So I guess that's called flyers.
That's an appropriate name. I didn't know that.
Yeah. So Mansfield provided very little to no instruction on how to do this kind of flying stuff. And that stuff, if anybody's ever seen it, you probably have, it looks pretty dangerous. And that's because it is pretty dangerous.
Yeah. I saw the movie Bring It On.
So some of the moves that she expected them to do were even illegal. They weren't even allowed to do those moves, and she was expecting them to do those things. And I guess what happened was a lot of times when they were practicing these moves that they weren't being taught properly or that were illegal, kids fell. They were dropped, right?
Sure.
And it looks like Mansfield's response when those things happened was to tell the flyers to, quote, brush it off, suck it up, and do it right the next time.
Okay. Effective coaching.
Very encouraging.
Shake it off, rub some dirt in it.
Yeah, you got it.
Get back out there.
So anyway, parents and cheerleaders voiced numerous concerns and complaints, had meetings with Burley High School and district administrators.
Good. Okay.
The result of that was Mansfield being placed on a performance improvement plan.
Oh, great.
Yeah, all of this stuff happens. Kids and parents complain, and the district or the school turn around and they say, this needs to improve. And that plan required Mansfield, among other things, to, quote, keep her communication positive with members of the cheer team. Things like refraining from texting cheerleaders one-on-one. So that was, I guess, a thing. She was texting cheerleaders, having... Oh. Yeah, that's something you kind of want to avoid doing.
That's such a huge no-no.
And refrain from discussing sensitive issues about the cheerleaders with others, and to be consistent and fair with all girls in the cheer program. So the information that the school got that they attempted to address in this performance improvement plan seemed to align with all of the factual claims that were presented.
Yeah, no, the PIP seems to be really appropriate here because we're addressing like communications, make them positive, like stop trying to motivate them through insults, assuming that that's what she was trying to do, right?
Right.
Don't talk about your cheer members with other cheer members.
Yeah.
100% on board. We don't even know about the text messages. So the text messages thing is totally new. And then, like being consistent, fair. So it seems like the school district is taking these concerns seriously because, right, they're stepping in, they're doing something like that they can point to. Like a PIP is a big deal. It creates a documentation train. It creates observation notes, check-ins, like to make sure that it's being realized. So this is not a small step for the district to take. Nope. So I really appreciate them taking these concerns seriously.
Yeah, exactly. But here's where it kind of gets a little muddy. Okay. At this point, it just says that her behavior did not improve. Okay. And then it goes on to say that as a result, students organized a sit-in to protest Mansfield's bullying, favoritism, and incompetence. All right. Now, I'm just going to back up a second and just throw this out there that we don't know the timing of when the parents and the students complained to the district, how long it took the district to create and implement this performance improvement plan, we don't know how long that plan was sort of in place before the students organized a protest. Correct?
Yeah, no, not from the evidence that the court provided.
So there's a lot of assumptions that we kind of have to make here. But these are things to sort of think about as teachers, as school administrators. You know, the possibility that these students had completely made up their mind about Mansfield. Is it unreasonable to assume that these students were not willing to give her a chance to make that improvement?
Right.
I think...
Right. It sounds possible for sure. Like,
it sounds possible.
it sounds like she lost the locker room, right?
Exactly. And listen, that could be on her, right? I mean, if everything that we're reading here is true, I mean, I'm not passing judgment necessarily on whether or not I could blame the kids for not wanting to give her a chance to improve. That's not what... All that I'm saying is that it's entirely possible
that no matter what Mansfield did at this point,
was done.
The kids were going to do what they were going to do. Yeah.
Exactly.
Yeah.
So anyway, just throwing that out there, what happened was students organized this sit-in to protest her bullying, favoritism, and incompetence. Right.
And that happens in the fall, right?
Yeah.
Like, so the protest is in September.
Yeah.
Yeah. And so like, she hasn't, I guess she started the last spring, right? Because she had to do tryouts.
Yeah.
But this is the beginning of the 2017-2018 school
Yeah,
year.
but I mean, like,
Still-ish.
I think there's probably a lot of stuff that could have happened between spring and September because, you know, like they could have had summer stuff going on and, you know, who knows.
Yeah.
So here's what the protest looked like. 14 cheerleaders went into the gym, sat on the bleachers for 2 minutes.
2 minutes.
Yeah. Before they were asked to leave by the athletic director and the assistant principal. Okay.
So all they did was this during practice? Like, when did this happen?
Yeah. So it was during practice. So during practice, they go in, they sit on the bleachers. 2 minutes later, they're asked to leave. One of those students argued with the AP and the athletic director. And that student said they have the right to peacefully protest. And they ended up leaving the gym and going to the library with the AP and the athletic director.
Okay. So making sure I've got this. 14 kids on the cheer squad come to practice, not ready for cheer practice. They go and they just sit on the bleachers during practice, don't take part.
Yep.
And this is their sit-in. This is their form of protest.
They were quiet, if not silent, like there might have been some whispering or something like that. But again, they go in, they're there for 2 minutes, and they're asked to leave.
Okay. Well, so they are in good company because students have been protesting at and against their schools for as long as there have been schools. Right. So like, you know, I'm not going to go too much into the history of student protests here, but let's just say they're in good company.
Yes.
But like, even calling this a protest, like, they sat there for 2 minutes and then it got disrupted by the AD and the assistant principal.
Right.
But the student who kind of stood up to them, because it sounds like the assistant principal comes in and says, hey, if you're not going to practice, I need you guys to leave the gym. Come with me to the library. Right? Is that pretty much it?
Right.
And the student who is kind of standing up for the group tries to talk them down, right?
Yep. Tries to talk them down.
And I think later it mentions that she had printouts of the student handbook that she was trying to read to the principal and the athletic director, which I love that so much. That
to use your phrase, Chris, she brought the receipts.
Right. She brought the receipt. She's got the handbook here that says, and you know, I did some research. I found the 2017-2018 student handbook, and it says,
what did she read to the AP?
These are the provisions that I would have read if I were in her situation.
Okay.
The student handbook says freedom of expression is an inherent constitutional right and is provided for in the school program. The right of free speech does not include the right to disrupt the educational process. When such disruption occurs, the student shall be subject to disciplinary action. The handbook also mentions student assembly. It says that students have the right of peaceful assembly in school facilities generally available to the public. All it says, though, is that such assembly shall be conducted in an orderly manner, not interfere with the educational process, and not impede the free movement of traffic. You know, I imagine that's what she was reading because that's what these kids were doing, right? Like, they were sitting on the bleachers. They were being quiet. They were being respectful, according to the students. they weren't interfering with the educational process, right? Like they were literally to the side. And they obviously weren't interfering with the free movement of traffic, right? Like they're not blocking anything. They're just sitting on the bleachers. So if I'm AM and I'm trying to read this and these administrators are telling me like, no, you can't do this. I mean, I get it because, and this is why we talk about like, it's so important to know your policies, right? Like you've got this policy. It focuses on disruption. It talks about whether or not it's orderly or not.
Right.
Like, I think based on these policies and, you know, based on my own kind of perspective on all this, like even asking them to leave was an unnecessary escalation.
Right. And potentially a violation of their policies.
And potentially a violation of their constitutional rights to freedom of speech.
Yes, as we will discuss. So here's how the school handled that. You ready?
Ready.
They suspended those students from the cheer squad for a week. All right. There you go. Around the end of that suspension period, the principal gave each cheerleader involved a list of additional punishments or consequences that they and their parents would have to agree to in order to get back on the team. Okay. So,
oh, wow.
They were like, okay, because of this protest, you're suspended for a week.
This 2-minute sit-in.
Yeah, this 2-minute sit-in. You are suspended for a week. And on top of that, if you want to come back, here's all the other stuff you have to do. You want to hear what they had to do?
I mean, no, but tell me.
So basically what it said was they were going to be suspended for about 3 weeks from all events and games, but they had to be at those events and games in their warm-up gear. Okay. And they also had to attend all practices once their initial week suspension was over.
Which is a little like a scarlet letter, right? Like, you can't participate, but you have to be seen being there so that everyone knows you can't participate.
Yeah. Okay, so you have to agree to that. You also have to agree that you will vocally address the entire cheer squad and the coaches that following Monday, okay, at the end of that first suspension with an apology. So you had to, when you come back from that first week suspension, you've got to verbally apologize to the rest of the team and the coaches. Okay. They were also required to participate in a 4-hour service project.
4 hours?
4 hours that had to be completed on one of the next few Saturdays. So it had to be completed before the end of October. And the date was going to be picked by the coaches.
Okay.
All right. They also, but wait, there's more.
Oh my gosh.
They also had to write a 1-page paper explaining why what they learned about themselves through that experience. They had to come up.
Self-reflection is good.
It is. They also had to come up with one team building activity or idea that they would present in that paper. They would be expected to follow the rules in the cheer handbook. And if they didn't, they would be dismissed from the squad. They would be expected to maintain a positive attitude and work ethic. So they were also forbidden from sending either negative texts or making negative social media posts about any member of the cheer squad. If they did, they'd be dismissed from the team.
Do you think that rule applies to the coach as well?
I mean, it seems like it was from the improvement plan.
That's true. Yeah, it was addressed in the performance improvement plan.
Yeah. And any parent activities, booster activities, things like that, fundraisers, whatever they did, would have to be cleared through the coaches. And they would have to agree to all of those conditions by the end of that week, the initial week that they were suspended. By 3:30 on Friday, they would have to agree to all of that. And if they didn't, they were done. They were off the team.
I mean, I see what the district's trying to do, right? Like they're trying to kind of, I guess, rebuild relationships. They're trying to like get the team cohesion back. Some of this feels a little bit punitive, right? Like 4 hours of community service. Like how does that, other than just trying to like, I don't know, like punish these kids for their 2-minute sit-in, like how does that address those goals, right? Like giving the district the benefit of the doubt. I see what they're doing. This again just feels like such a huge escalation from what actually happened, right?
Well, I completely agree. I mean, like disproportionate feels like an understatement.
Yes.
Right? Like again, they organized this 2-minute or what amounted to a 2-minute protest before it was sort of broken up, that they were potentially well within their rights and well within district policy to do. And they were suspended for a week with a whole bunch of additional conditions and sort of degrees of suspension for the following 3 weeks.
Yeah. I wonder what the board policies said at this point about like suspension or discipline from extracurriculars.
Right.
Because like it seems like they're playing fast and loose here with like, I doubt the district policy says, and after we suspend you, we'll give you additional punishments.
Yeah.
Right?
But wait, Chris, there's more. It gets even better.
That should be the title of the episode.
Yeah. Right. So what the students did was they all signed it. Okay. They all agreed to it.
That's a lot. I don't think I would have signed it.
Well, so here's what they did. They signed it and they included a letter that said, we are signing this, but we want to reserve our right, emphasis on right, to be afforded our rights in the district's grievance process.
Okay.
So they're basically saying, okay, we'll sign this, but we still want to be able to participate in the process that exists to basically state that we have concerns.
Yeah. And to either, and I'm not sure what they mean by grievance process, but it could be like to either appeal our punishment, right? Because there could be an appeal process for challenging the punishment itself, or it could be a grievance process like
making a statement at a board meeting or something. Yeah.
Right. We've got issues with this coach. We want them to be addressed.
Yes.
So we're going to sign this, but
they're basically saying, whatever this grievance process is, we want to be able to engage in that process.
The thing we have a right to under board policy, according to them, we want to do that thing. Okay. And the district had no problem with that, right? Because they've already got a right to it. And
they had so little problem with it that they decided to just go ahead the next day and dismiss all of them from the team for the balance of the year.
Oh.
Yeah, that's not
No, that's not what I expected.
No, yeah. So basically what happened was the district said, here are all these conditions. If you want to remain on the team, here's all the conditions that you need to agree to. And the students said, okay, we'll agree to those, but we want to be able to have the right. We're not saying we're going to do it.
Yeah.
But we're letting you know that we want to reserve the right to just engage in the existing grievance process. And the district came back and said, whoa, you know what? Forget it. You're done.
Who did that letter come from, right? Like, was that
That was the superintendent.
What? So, okay. So we started with a 2-minute sit-in during cheer practice. And now we're getting letters from the superintendent.
Yep. Kicking us off the team for the entire year. And this is early October.
For reserving their rights.
Essentially in both cases, right? In the case of the protest and in the case of just adding this little letter saying, we want to be able to engage in the grievance process if we want to, you know? And it's just like this one is that it's like this case, it just keeps getting better and better and better.
Yeah.
The dismissal letter stated in part that it is clear to district level administration that while the stipulation agreements were returned, the presence of the additional page or addendum suggests a continued conflict on the part of the cheer team, the individual student and parents with the coach and school administration. Such an expression is interpreted to be a desire to utilize the grievance process as opposed to the solution propounded by the administration. It is the belief of the school superintendent and the assistant superintendent that the school and the cheer team would be best served by revoking the membership of each cheerleader on the BHS cheer team effective Monday.
Wow.
So
because you included the addendum, we're kicking you off the team.
Exactly. And they're basically saying, we're interpreting that inclusion of the addendum as a desire to utilize the grievance process as opposed to the solution propounded by the administration, which is not true because they agreed to it. They signed it. And they even said, we're signing this. Right.
But we're also going to pursue other avenues of redress.
Right. And the district looked at it and said, you can't do both.
Right. That's evidence that there's still conflict and we don't want conflict. So let's get rid of these cheerleaders from the team.
Yeah.
Okay.
So, wow.
Right. Well, and the kicker to all of these kickers is that there were 14 cheerleaders who did the sit-in. There are 9 cheerleaders who got kicked off the team who put this addendum in the letter. And then, but the cheerleaders who engaged in the sit-in, who didn't put that letter saying we reserve our rights to go through the grievance process, they were allowed back on the team. So the only difference here is that letter, which is, as we'll talk about in a second, protected speech.
Yes, exactly.
Oh, okay, good. Well, I'm glad I'm on the same page.
So, I mean, listen, I think before we even get into what the court did with this, you know, which is probably pretty obvious at this point, like, you know, there's so much here that, you know, you're probably listening to and are like, well, this was a little over the top.
Well, maybe, but like, that's kind of what happens with student protests, where there's an instinct to come down hard or to overreact. You know, the purpose of protest is it happens when people don't feel heard in other ways. And so coming down hard on these students just kind of reinforces the power dynamics and the fact that they don't feel like they have a voice. And then to further punish them for saying, we're going to continue to have a voice, we just wanted to let you know, we agree to all your stipulations, that just further kind of solidifies the fact that the district isn't communicating to the students that they are listening. And I think that's the biggest thing right here.
Right. Yeah. Well, so what'd they do?
Well, they brought a lawsuit.
Hey, look at that.
Hey. Yeah, I know. That's always a surprise probably when I say that in these episodes. So the 9 cheerleaders who got dismissed from the team all bring a lawsuit against the district. So they sued the district, the principal, the superintendent, the assistant superintendent, everybody who was involved. And they allege 2 First Amendment retaliation claims. And so this is basically them saying, you took some action against us because of our speech, and that action was problematic. And so the first one is for the 3-week suspension and the other punishments that they had to agree to for the sit-in. And then the other one is the decision to kick them off the team after they reserve their rights to engage in the grievance process. So they're essentially saying we engaged in 2 speech acts and you punished us for both of those. And that was impermissible retaliation for our protected speech.
Okay.
And so the decision that we're talking about today is from the U.S. District Court for the District of Idaho. So we're at the trial court level in federal court because these are U.S. constitutional claims. And the decision, as we talked about earlier, is coming at cross motions for summary judgment. So both parties moved for summary judgment. The school wanted to get everything dismissed or get everything decided. And the students only asked for summary judgment on their claim related to the letters, reserving their right to engage in the grievance process. They actually didn't ask for summary judgment on the first one about the protest, probably because they didn't think that the facts were undisputed. They probably wanted to develop those facts a little bit more. And so, you know, we've got this First Amendment retaliation claim. A First Amendment retaliation claim requires the plaintiff to show 3 things. Were they engaged in constitutionally protected activity? Did the defendants take some action against them that was motivated in part by their protected speech? And 3, did the defendants' actions, would those chill a person of ordinary firmness from continuing to engage in the protected activity? Put that another way, simply, was the plaintiff engaged in protected speech? Did the defendant do something because of that speech? And lastly, would that prevent someone from wanting to engage in that speech?
Well, that seems cut and dry given what we've...
Pretty straightforward, right? Yeah. So looking at the sit-in, and this one, the court actually doesn't decide this one because they just decide that the school district isn't entitled to summary judgment. So they start with Tinker and basically say that students have speech rights in schools. School officials can only curtail student speech if it constitutes a material and substantial interference with the educational environments or intrudes upon the rights of others. So I know we've talked about Tinker a bunch, so won't go too much into Tinker. And the court basically says that school, you didn't point to any disruption here. Like, you can't punish these students because you weren't justified.
You didn't meet that Tinker standard.
Right. And this actually is a little bit different than our Trump 2016 case.
Yeah, because it caused
the
disruption.
Well, we can agree to disagree on whether or not that was a material and substantial disruption. But the court here basically says, like, disrupting one class for a few minutes is not enough. It's got to be bigger. It's got to involve the school. It's got to involve all of these other things beyond just like that one classroom for 2 minutes, right?
But I would say, in that respect, it's pretty similar to the Trump 2016 case that we talked about before, the Talladega case.
Right.
Because that's pretty much all that happened there. It was in one classroom. It was sort of a contained disruption, but the school had a lot of things in place, not to restrict that speech, but to sort of channel it
right? In the productive means. Yeah.
Anyway.
Yeah. I won't relitigate the Talladega case. So anyway, the school is arguing that the sit-ins ought to be viewed as unprotected speech because they disrupted cheerleading practice. They disrupted practice, right? Somebody had to come in and get them out of there. They're saying that it disrupted practice as well because the cheerleaders weren't participating and it was harder for the other cheerleaders who did want to practice without them. And then the argument that gets me is they also argue that it's a substantial disruption because the principals had to take time out of their day to deal with it.
No. Listen, I can get a little on board with those first things, right? You have a limited number of folks at these practices. Having 14 kids sit out could cause some problems in terms of the ability to run that practice. I get that. But saying this is going to take our principal is going to have to take a little bit of time to deal with that. That's your job.
That is exactly what I thought. To me, that was that a lawyer came up with that argument.
Yeah, sure.
Right? That's a lawyer who doesn't know how schools work.
I mean, whether we're going to fault the principal here or not, I would hope that if any principal heard a lawyer saying, okay, and we're going to make this claim, okay, that this took time out of your day to deal with, I would hope that a principal would say, you know what, we could just go ahead and leave that one out because I deal with crap all day. That's what I do.
Right.
Is people call me to help them deal with stuff. That's my job.
Yeah, right. No. So the court looks at all this and kind of dismisses all those arguments for almost exactly what we're talking about here. And they just say this was quiet. It was peaceful. It wasn't disruptive. I don't have any evidence of a disruption here. So I can't grant summary judgment for you because even the disruption that you potentially do point to, that's just too de minimis. It's too small to be to meet that Tinker standard for material and substantial disruption. So the students, they don't win this one, right? They don't win at this point, but they don't lose it either. So the school district does not get summary judgment, which means that this claim is going to move forward. If there's a trial, it would go to trial. If it gets settled, it's still alive, essentially. So the second retaliation claim, this is the one for basically getting kicked off the team for reserving their rights. This one is a little bit different because the court says that everybody agrees that this is protected speech. We were fighting about whether or not the sit-in was protected speech because maybe there was or wasn't a disruption. This one, district, students, everyone says this is protected speech because you can't point to a disruption here, right? They literally just wrote down on a piece of paper, hey, we're going to use the grievance process. And that's totally protected speech.
They actually didn't say we're going to use the grievance process. They said, we want to remind you that we have that right. And we might.
Yeah. We might. So both parties agree this is protected speech, right? And that's our first element of a retaliation claim. The other two elements are the ones that are a little bit more in question. The question of, was the district's action motivated by the speech or related to the protected speech? And then that other question, whether or not the district's action had a chilling effect on those protected activities.
Okay.
And so that's where the district is kind of arguing here. They're not saying that this is unprotected speech. They're saying, look, we did what we did, not because of what they said. We did it for completely legitimate reasons. And the court looks at that and says, but your letter said you did it because of their speech. And you also let the people who didn't put the disclaimer back on the team. So that argument is pretty.
Yeah, you can't have it both ways.
Yeah, that one's dead on arrival. And so the last issue here is would this have a chilling effect on free exercise? And the district is saying, it's not really having a chilling effect because, these students engaged in their protest. And then after all of this went down, they did go through the district grievance process according to the district. So the district is saying it didn't have a chilling effect because they still went through with it And if it had a chilling effect, they wouldn't have gone through with it. My thought is, well, they had no reason not to go through with it. You already kicked them off the team.
Yeah, they were done. Yeah, exactly. Like,
right. And so the court comes back and says, like, the chilling effect isn't necessarily whether or not it chilled these students. The chilling effect question is whether or not an ordinary person would be like less likely to engage in protected activity because you did something to them.
Yes.
And here, like, if you suspend kids for 3 weeks from the cheer squad, if you kick them off the team for reserving their rights to engage in a protected activity, like, that's going to make people less likely to do that thing in the future. So, like,
totally.
Clearly this has a chilling effect. And so because the speech is protected, because there's a causal relationship between the speech and the punishment, and because there's this chilling effect here, this is a First Amendment retaliation violation. So basically, you violated the First Amendment school district when you kick these students off their team for their reserving their rights to engage in the grievance process.
Okay.
And that's a problem.
Yeah. You think? That definitely is a problem. Well,
yeah. And so the plaintiffs got summary judgment on the second one. And then there's also a qualified immunity issue in here because why wouldn't there be, right? But like the district kind of very quickly deals with that and says, it's pretty clearly established that you can't silence students unless there's a material and substantial disruption or some other situations that aren't relevant here. So no qualified immunity.
Yeah, that makes perfect sense. Yeah.
Yeah. And so the court grants the plaintiff's motion for summary judgment on the second retaliation claim, and then the parties settle the case.
All right. And we don't know what is in that settlement, right?
We don't know what's in the settlement, but we do have a very interesting tidbit from the court after the settlement was signed.
Okay.
So they engage in this settlement. We don't know what's in the settlement, but we know what's not in the settlement. Attorney's fees were not included in the settlement. But because the court concluded that there was a First Amendment violation, the civil rights kind of fee shifting statute takes effect where the district could be on the hook for the plaintiff's reasonable attorney's fees.
Okay.
Typically, you have to pay your own attorney's fees, but with civil rights statutes, and we talked about this with IDEA as well, they both have fee shifting statutes. So there was a motion the plaintiffs filed to get their attorney's fees, and the court ordered that the school district pay a little bit less than $400,000 in attorney's fees and costs to the plaintiffs. And that was just to get through summary judgment. It didn't go to trial. It didn't get appealed. And they still owed, like, I think it was $388,000.
Whoa.
Yeah.
That's crazy.
And then the other thing that my research kind of turned up in this whole thing, and maybe we should have mentioned this earlier, but at the end of the 2017-2018 school year, so that same school year, the district's school board minutes for April indicate that Miss Mansfield and the district parted ways at the end of that school year. So she was no longer the cheer coach, and her assistant coach also separated from the district at that time too. So we don't know from the document that I was able to find kind of what happened. Like, we don't know if she resigned or whatever.
Yeah, it just indicates that there was a separation.
Right. So all that to say is, after all this stuff went down in the 2017-2018 school year, Mansfield was not the coach the next year.
Okay. Well, then there you go. I don't really think we need to go into too many details here about big takeaways.
Don't violate students' rights.
Don't. Like, I mean, I think should be pretty obvious at this point.
I mean, my big takeaways, and these are two that, like, we've used a bunch in the past. Know your policies and follow them.
Right.
Right? Like, you're not playing improv here.
No.
You've got policies. Make sure you follow them. Make sure you're consistent.
Yep.
And then the last one is just like, especially with student speech, there's so few ways for students to have their voices heard.
Right.
If they're engaging in this kind of protest activities, like, they're doing it for a really good reason to them. And you might not understand that, but like, it's so important to listen. And that like, listen, acknowledge, work with them to the extent you can, and then like, don't respond with kind of these punitive impulses.
Yeah, exactly. I mean, like, I think it goes back to what we always say over and over again on the show and in my classes as well. I say this all the time. It's like, it's all about relationship building.
Right.
And if you can build productive, meaningful relationships with people, your teachers, your parents, and your students,
Right.
okay, then, it is much less likely that any of this stuff is going to get to this particular. If students feel heard and valued, that is not the same thing as giving into student demands.
Exactly. Yes.
If they can feel heard and valued and respected, they are going to be much more open to hearing an answer that they don't agree with.
Yeah, because you've got a relationship to fall back on.
Exactly.
Especially in this case where there was already issues with the teacher. So like maybe the students were onto something, right?
Right.
Like,
I mean, I can't tell you the number of times that I had to make decisions that I knew the students were not going to be happy about. But I took every opportunity that I could to, and these were middle school students, I took every opportunity that I could to be transparent and listen. Of course, there were always times where it didn't matter what explanation I gave or how transparent I was or how nice I was trying to be or whatever. There were always, there was always going to be somebody who was just, going to fight.
Right.
Okay. But that was much fewer and further between.
yeah.
Right.
Especially it wasn't every time, which is what kind of happens if you basically dig your feet in.
No. And, and then you've got the sort of that sort of group mentality kind of thing where,
Right.
You've got a larger group of people who say, all right, I might not agree with this, but I understand where he's coming from. I respect that decision. He was very transparent about this. He was blah, blah, blah. And so the one person that, is really upset about it, it's much harder for them to sort of get a critical mass to come and, gang up on the principal or whatever. So it's all about relationships. And I really want to stress this one thing I really want to stress the most, because this is something that I am very passionate about, both when I was a principal and now in my scholarship as well, is the relationship between administrators and students. It's not something that gets talked about enough.
Yeah.
And it is very powerful and it is very important. So, it's not just about the relationships that you have as an administrator with teachers or the community or parents or whatever. It's students too. Anyway.
Yeah.
All right, folks. Well, that does it for this episode. Chris, let's do a quick homework tonight.
All right. Your homework is to show some spirit and rate, and review Chalk and Gavel wherever you find your podcast. You can find us on social media at Chalk and Gavel, our website, chalkandgavel.com. We'd love to hear from you. Love to continue the conversation. Let us know if you've got ideas for episodes or bell ringers, or if there's just something you want to share with us. We'd love to hear from you.
Have a good one, everyone.